Good afternoon, everybody, and thank you for joining us in today's session, focusing on recent changes to the Employment Relations Act. Various amendments. I'm Peter Kiley, and I'll be joined by my colleagues David France and Hannah King, and we're going to have a look at these amendments, tell you what's changed, and what they might actually mean for you in practice. We want to keep it very much a practical session. The Holidays Act has been something people have been chasing for years to improve, and I think that has happened. So on the agenda, we're going to look at the key amendments to the Employment Relations Act, the new gateway test. What is an independent contractor? Who is an employee? What's the difference? What the new $200,000 remuneration threshold means in a practical sense. If there is a personal grievance, what does it mean? What remedies, what relief can an employee seek? And for those of you involved in collective bargaining, a 30-day rule. David's going to cover that, and then Hannah will move into what we now are going to call the Employment Leave Bill to replace the Holidays Act. So that'll cover sick leave, annual leave, public holidays, etc. We want to keep it strictly to an hour, and then we're going to conclude with a question and answer session. So what you should do for the question and answer session, if you go to the bottom bar of your screen, you'll find the question and answer question. They'll come and then go ahead. So without further ado, David, let's address those amendments to the Employment Relations Act.
Thanks, Peter. In fact, Hannah, I'll get you to do the gateway test around
Yeah,
the difference between independent contractors and employees and some changes to the rules around that, and then I'll move on to the rest of the amendments. So
yeah,
thanks.
I think that's great. So maybe if we go on to the next slide. Hi, everyone, and thanks for joining us all today. I'm going to talk about this gateway test because we now have this as part of Section 6 of the Employment Relations Act. It's been a concept that the government has talked about since about September 2024, and it is finally in place. So Section 6 of the Employment Relations Act now it states that the meaning of an employee excludes what's called a specified contractor. That's down at the bottom, subsection 7 of Section 6. Sets out this definition for a specified contractor, and that is our gateway test that we have heard about for a very long time now. So what is it? Well, there are essentially 5 criteria. You might hear people talk about 4 or 5, but really in my mind it's 5. And if all 5 of those criteria are met, then a person is characterized as a specified contractor. And that means that they don't fall within the meaning of an employee under the Employment Relations Act. And they sit outside of that framework. So what are we talking about here? Well, the Act now says that a specified contractor means a person who has entered into arrangement with another person under which the person either performs work for, we'll call it an organisation, or performs work for a third party that is facilitated by that organisation, and meets the following 5 criteria. So number 1 is that the worker must have a written agreement in place specifying that they're either an independent contractor or not an employee. The second criterion is that there must be no restrictions on the worker working for others, including competitors. Number 3 is that the worker must not be required to work at a specified time or on a specified day or for a minimum period, or they must be allowed to subcontract the work to a third party without the organisation or the business needing to vet that third party, unless, of course, that vetting is required either by statute or is justified due to the nature of the work for reasons such as finding out relevant qualifications or doing a criminal record check or both of those things. The fourth criterion is that the arrangement can't be terminated for the reason that a worker is declining to do additional work offered that they haven't agreed to perform under the arrangement. And number five is that the worker needs to have been given the reasonable opportunity to seek independent advice before entering into an arrangement, much like that requirement that we see with our employment agreements. So look, if a worker fails to meet any of those five criteria, then, well, if they meet them all, then they are a specified contractor. If they fail to meet any of those five criteria, then Section 6, as it stood prior to the Employment Relations Amendment Act being enacted, prior to the 21st of February, Section 6 will still apply. So look, they can still be considered a contractor even if the worker doesn't meet these new gateway test criteria. It's just that in that circumstance, there'll be the standard test applied of what is the real nature of the relationship. And that test will be applied using the guidance that we've seen in our classic cases, such as Bryson and 3'6", and also in the recent Uber decisions. So on to the next slide. What does this mean for everybody? Well, some of you I know on the call don't use contractors, but others of you, I've seen the list, some of you have got a sizable part of your workforce engaged by a contract. So what does it mean? Well, look, it could be the case that you don't want to do anything at all, or it could be the case that you decide to make changes. In terms of what the courts are going to do, if a working arrangement meets the gateway test, then the worker is going to be considered a specified contractor from the 21st of February this year. And that's the case regardless of whether the arrangement began before the Act came into play. That is, unless proceedings have been filed. So if you've got proceedings, some worker status proceedings on foot, then the specified contractor test is not going to apply to that matter that's before the courts, but otherwise it will. Now, workers can, of course, still bring a claim in relation to what happened prior to this new Act coming into play. So there is that to keep in mind as well. But I think from my perspective and what I'm talking to clients about is, what do we want to do with the people moving forward, right? Is the gateway test, do those five criteria provide you with an option that you didn't have before that's going to be operationally viable in your business? And in particular, when we're looking at, can this worker work for others? Because I know that there is often some sort of restraint in play in contractor agreements. Is that going to be possible to remove? And also the other one really being, do we need to restrict this person in terms of the hours that you're doing for us? Do we need them to carry out the services at a particular time? Are we happy with a subcontracting arrangement if they can't do that? And if the answer is no, then you're probably going to be leaning back on what you had before. But what this provides is a new option for business that hopefully can provide a bit of flexibility and certainty where we didn't have that previously. So with that, I'll pass back to you, David, to talk about the other changes that we've seen. And I think you might be on mute.
Thank you, Hannah. One of the most common statements heard over a Zoom or Teams meeting over the past 5 years. What I'm going to be addressing is these changes to remedies which have been introduced under the Amendment Act, and changes around personal grievance law, if you like, and a few other features which relate to that. And then I'll move on to looking at what changes have been made which may impact on collective bargaining. If we talk about, or the session I'm going to talk about in relation to how the authority will be addressing remedies following a personal grievance hearing. I'm sure most people on this call try and avoid going to the Employment Relations Authority, so don't want to find themselves in a situation, if you like, where they are at the mercy of the authority when it comes to determining whether or not an employee has a personal grievance claim, and if so, what remedies they are entitled to. But there are also occasions where you can't control whether you're going to be in the Employment Relations Authority or not. And that's what I'm going to be focusing on and talking about remedies and how that's changed. So under these amendments, there are now more limitations on remedies that grievance or claimants may be entitled to when pursuing an unjustified dismissal claim in particular, but also in relation to unjustified disadvantage type claims and similar grievances. Where the change is most significant is, in particular, is the case where an employer may be investigating allegations of serious misconduct, finds that serious misconduct has occurred, dismisses the employee, and the employee then brings an unjustified dismissal claim. Now, from all dismissals that have occurred that may occur from 21 February this year, if they're challenged in the authority and the authority determines that an ex-employee, the dismissed employee pursuing the unjustified dismissal claim, was dismissed for behaviour that amounts to serious misconduct, and the dismissed employee contributed to the situation giving rise to the grievance, then that individual will be entitled to no remedies. So logically, that applies to situations where the employer has failed to follow a fair process in some form before dismissing the employee, such that the dismissal could be considered unjustified. But despite the failure, the authority determines that the employee's conduct for which they were dismissed amounted to serious misconduct. So there's got to be a finding first that the dismissal was unjustified, and then what the authority will do is look at, well, but was the dismissal itself for serious misconduct? And if the authority determines the employee's behaviour amounts to serious misconduct, then the employee will not be entitled to any remedies in that situation. Aside from a situation where the authority determines that the employer's dismissal was due to serious misconduct, there's also other limitations on remedies an employee or a claimant may be entitled to if they pursue proceedings all the way through to the authority. This is whether they're a dismissed employee or whether they're an existing employee, perhaps bringing an unjustified disadvantage claim. So in those types of cases, so we're not talking about serious misconduct cases, but in cases where the authority determines that there are grounds for the grievance, the employee has been disadvantaged in their employment due to an unjustified action by the employer, but that employee, through their actions, contributed to the situation giving rise to the grievance. So they had some role in the action or the unjustified action the authority has determined the employer engaged in, then that employee will be restricted in the remedies that would be available for them. So in a dismissal case in particular, maybe not for serious misconduct, but for repeat misconduct or for performance, if you like, as another example, if an employee brings an unjustified dismissal, unjustified disadvantage claim, they're found to have grounds for that claim, but they contributed through their actions to the reasons for the unjustified action, then that employee will not be entitled to reinstatement of that claimant, and that claimant will not be entitled to compensation. They will be limited in their entitlements to lost remuneration claims, basically, if they have suffered any loss. So really these changes are more of a focus on employee behaviour than has been the case for many years. It reduces to a degree the focus on process, provided there's provided that there's contribution by the employer, provided that there's a finding by the authority of serious misconduct. So how that impacts in your day-to-day dealing with misbehaviour and the like, if you like, in the workplace, it doesn't really. We're encouraging clients to still follow their standard disciplinary processes as you'd currently follow. This is really about how the authority is going to look at things if you ever get to the stage where you've facing a personal grievance that finds its way to the authority. So you always want to go into the authority with your best foot forward, being able to show you followed due process, being able to show that the decision you made was a decision that was available to you and all the evidence at the time. It also will help, no doubt, in relation to negotiating settlements, which you may find yourself in if employees challenge their dismissal or if employees challenge the way they've been treated by the employer. Moving on to slide 7, part of the question that often arises now in relation to this change around serious misconduct is what constitutes serious misconduct. And that will become a big issue before the courts. There's no definition in legislation as to what constitutes serious misconduct. All we know is that it's a high threshold. It needs to be behaviour which irreparably damages the employment relationship. And that's not a subjective view. So just because you, the employer, thinks something has irreparably damaged your employment relationship to the extent that you consider serious misconduct has occurred doesn't mean the authority will agree with you or the court will agree with you. It's the test of whether a reasonable employer would have determined in all the circumstances that the behaviour constituted serious misconduct, and that's what the authority will be, or the court will be assessing if someone is dismissed for serious misconduct and pursues an unjustified dismissal claim and is successful in proving that due to procedural flaws, the dismissal was unjustified. The court will then look at, well, what's its definition of serious misconduct and has that been met in these circumstances? Serious misconduct, as we know it, though, it will be consistent with often definitions in your code of conduct. Some people have it defined in their employment agreements. It's dishonesty offences, it's violence in the workplace. It's that type of behaviour which is generally covered, the standard type of behaviour covered in codes of conduct and disciplinary procedure policies and the like. So as I say, currently our advice is stick to your disciplinary processes, follow your disciplinary procedures if you've got a policy which sets out your obligations in dealing with alleged misconduct or alleged serious misconduct. That will set you up to be in the best position if ultimately you terminate someone's employment or if ultimately you issue someone with some form of disciplinary action less than termination and that is challenged. That moves up on to the next topic, which is the high income threshold amendments, which have been introduced under the Act. These got some media attention over the past few months as they were being discussed in Parliament, and when the amendments came into play on 21 February. And basically that situation is that there is now a $2,000 cap on earnings, on remuneration, which means that if the annual remuneration of an employee meets or exceeds this amount, an employer is not required to follow a good faith process when terminating the employees who fall into this category, and the employee cannot pursue a personal grievance for unjustified dismissal. So this has more practical relevance for employers in relation to those employees who earn over 200,000 currently, as to how you're going to deal with this high income threshold law moving forward. What it means is in relation to not having to follow a good faith process is that an employer is not required to provide an employee with access to information relevant to a decision to terminate that employee's employment, and the employer is not required to give an employee an opportunity to comment on a proposed termination before taking that step. The employer is also not required to provide reasons for the termination of an employee's employment if they fall into this category. There is a 12-month transition period, and that means effectively for existing staff who were employed as at 21 February or prior to that date who earn 200k or above, this threshold test won't apply to them for the first 12 months. That covers people who hold the same position as before the threshold cap was introduced, or during the 12-month period are restructured into a different position but continue to earn over that 200k with their employer. Also, what the new law provides is that an employer and employee can contract out of that threshold cap through agreeing to retain a personal grievance protection clause available to employees who earn over $200,000. That's a decision which employers will have to form a view on whether they want to be able to make use of the high income threshold law, or whether from their perspective and their culture and the way they operate their business, they want to ensure all employees have availability to personal grievance provisions if they feel aggrieved about the way they have been treated, or if they feel aggrieved about how their employment has been terminated. It doesn't prevent individuals pursuing other forms of grievance claims. So what you find overseas, where they have similar threshold income tests, is that discrimination claims start to escalate, and other forms of claims start to escalate, where employees are disgruntled or aggrieved with their employer because due to their being and earning over 200K, over that threshold, their employment is terminated for no reason given whatsoever. So you will have to be aware that employees, if they're aggrieved, will simply find other ways to challenge the employer's conduct and behaviour. Now, currently, the threshold's 200K. That's not fixed. It's going to be reviewed pursuant to a calculation which is provided for in the Act, and which is far too complicated and dry to take you through today. I believe the next review will be in mid-2027, and I believe that what the new threshold income amount is, come that time, will be announced through the appropriate channels. So it will change over time, and it will no doubt increase over time. So moving on to the other slides dealing with the remuneration threshold. I've talked about the transition period. It's 12 months. I've talked about the Act allowing employers and employees to contract out of that threshold, the threshold rules by agreement. So you can expect employees in the upper income brackets perhaps to come armed to negotiate the ability to retain the professional grievance protections that exist in the Act, or come armed to negotiate some other form of protection, which means that if they are terminated by their employment without cause, or without being informed of the reasons, then there is some other protection that is provided to them. And often we'll see those in no-fault termination clauses, which are included in employment agreements, which to date have been questionable about their legality, but moving forward will certainly have more legality and more oomph behind them when it comes to employees earning over 200K, if as part of that you have some form of provision in their employment agreement which says that if we terminate you on the spot without any reason, you'll be entitled to X months pay, or something along those lines. All right, looking at other changes that have arisen under the Amendment Act, there's some minor changes relating to the law concerning personal grievances. It's along the lines of what I said earlier. Procedural flaws and dismissal processes are less likely to support an unjustified dismissal claim if it's determined that the flaw did not result in the employee being treated unfairly. Again, that's not a ticket to taking shortcuts in processes, but it gives you some security if for some reason a process is followed which perhaps has skipped what would otherwise be considered a step a fair and reasonable employer would take, and you can show that, well, actually, yes, maybe we did skip this, but the employee wasn't treated unfairly as a result of that. There's also some recognition now under the Act that if an employee obstructs a disciplinary process, doesn't cooperate with a disciplinary process, avoids meetings, etc., unreasonably, then that may also be a factor which impacts on an employee's entitlement to remedies in a way which wasn't previously, or hasn't previously been the case. All right, that brings us on to changes relating to collective bargaining and unionised sites. The key one, of course, is the removal of the 30-day rule. Anyone who's been around for the past 15 or 20 years knows that this is something that comes in and is removed depending on who's the government of the day. So this isn't our first rodeo with regards to removal of the 30-day rule. We've done it. It's happened before. You no longer need to employ non-union employees whose work falls within the coverage clause of an applicable collective agreement on the terms and conditions based on the collective agreement for the first 30 days. The exception to that, of course, is those collective agreements which have enshrined as a term that employees or new employees covered by the collective agreement who are not union members will be employed on the terms of the collective agreement for the first 30 days. If you've got that term in your collective agreement, then this change doesn't affect you until and unless you can negotiate it out of your collective agreement. But otherwise, if it's not there, if it's not a term of your collective agreement, lucky you, you don't have to employ new employees who are not union members covered by the collective on the terms of the collective agreement for the first 30 days of their employment. Employers are also no longer required to provide certain information about the union to new employees or to share information about the new employees with the applicable unions that they have employment relationships with. This is what was introduced and called the active choice form, which employers on unionised sites had to complete, but those active choice forms are no longer required to be completed by employers. You still need to inform a new employee who's not a union member that the collective agreement exists and covers the work done by that employee. You still need to inform the employee that the employee may join the union. You still need to advise them how to contact the union and advise them if they join the union, they'll be bound by the collective agreement. And you also still need to provide a copy of the collective agreement to that new employee. So those fundamental obligations, which have been in place for a long time, continue to apply on unionised sites. So that covers the key changes that have been introduced under this amendment. As I say, they came into force on 21 February for people who have matters in the authority at the moment which predate 21 February. It's unlikely you'll be able to take advantage of any of those changes, but from 21 February onwards, any actions that are taken by the employer which result in proceedings being filed in the Employment Relations Authority and which are captured by these amendments will be reviewed and determined in the context of these changes to the Employment Relations Act. I'll now pass you back to Hannah, who is going to give an overview of the Employment Leave Bill, which came out a week or two ago.
Thanks, David. So yes, that's right. We are ripping up the Holidays Act 2003 and trying to replace it now with something called the Employment Leave Bill. So it's out with AWE and RDP and ADP and all of that, and we've got a new OWD. Really what we've got is a complete overhaul of the holidays legislation, which of course has been on the cards for many years now, and I think will be welcome across a number of industries. So look, this was introduced 9 March, had its first reading on the 12th of March. The submissions are due to Select Committee on the 14th of April, and those Select Committee hearings are due to start on the 22nd of April. So we are really looking at getting this through with speed, and the Minister has indicated that she wants this done and dusted by the end of the term, and I think that is certainly what we're going to see. What we have with this Act or the bill is several important changes. The aim, as it has always been, is to replace the Holidays Act 2003 with something that is simpler, clearer, and more certain. Particularly for those employees who have irregular work patterns. So what we've got is really one of the biggest shifts is how leave entitlements are going to be calculated. and also paid, to really just simplify that calculation and make it very clear what entitlements will be for those with unusual work patterns. The bill, when I like to look at this, we've got the leave entitlements on one hand and leave payments on the other. The key difference, which I'll go into shortly, is that we're now splitting hours into standard hours, additional hours, and casual hours. And then in terms of payment, what we will see if this bill comes into law is that we're going to have payment dealt with by a single rate, which will be welcome news, and also something introduced called the leave compensation payment, or the LCP, and that's going to be a loading of 12.5% to be paid on additional hours and casual hours instead of leave accruing on those types of hours. So we're looking at an hours-based framework. You're going to get entitlements from day one. And under this bill, there's also a new otherwise working day test, which I think should make things a lot simpler for everyone. So if we zoom in and take a closer look at these proposed changes, what we see is that there is this concept introduced of categories of hours. There's standard, additional, and casual. Now, standard hours are the hours that an employee is required to work under their employment agreement and for which the employer must pay them, regardless of whether the employee is ultimately actually required to work those hours. The Act or the bill provides for the situation where the employment agreement doesn't provide sufficient detail as to what standard hours are. And in that case, the bill is requiring parties to the employment relationship to come up with what it terms a notional roster to base entitlements on. There's going to be a second category of hours called additional hours, and these are hours that are worked additional to standard hours. Two categories really. The first being that these additional hours will be any hours that are worked in addition to standard hours that the employer wasn't required to make available, but did, and the employee had the right to refuse, but took up the option to work those hours and was paid an additional payment. Those are going to be classified as additional hours, and also hours that are worked under an availability provision. Those hours now attract the LCP or the leave compensation payment. And then finally, the bill proposes a third category of hours called casual hours. They are the standard, what you would understand under the current law to be casual hours, that is, hours that are worked by an employee whose employment agreement doesn't require the employer to offer hours and doesn't require the employee to accept them. So those are the casual hours. So if we look first of all now at annual leave, I'm going to take us through annual leave and sick leave and public holidays. Under the bill, the employees would be able to accrue annual leave from day one of employment and on an hours base. Rather than a weeks-based approach, at the rate of this very complicated figure, 0.0769, that really is 4 divided by 52. So your entitlement to leave is pretty much the same, but it's done now in hours and accrued from day one. So annual leave is going to accrue under the bill when workers are on any paid leave under legislation, certain unpaid leave types as well, but it's not going to accrue when workers are on ACC or any other unpaid leave that's not specified specifically in what will be the Employment Leave Act. And now employees are going to be able to use that accrued annual leave to take any part day off. It can be used in hours, and there is the ability to cash up as there is now, along the lines of what we have now, but framed slightly differently. Essentially, you're going to be able to request to cash up 25% of your annual leave per 12 months. In terms of sick leave, again, the we're looking at this on an hours based, and we'll just move to the next slide now so we can look at sick leave. An hours-based approach again, accruing at, again, a funny figure, 0.0385. That essentially means 2/52, the same essential proportion that we've got right now, accrued at that rate on every standard hour worked. Interestingly, there is now a cap of 160 hours, so employees are going to have to stop accruing. Well, under the Act, they stop accruing at that 160-hour point. Once that cap's hit, an employee would stop accruing until they've used some of that stored entitlement. And employees will have that time deducted on sick leave by the hour from that accrued balance, and they can use it, obviously, therefore, to take a part day off, an hour or two off for the doctor and the like, and to do so against standard and additional hours, those categories of hours that I talked about earlier. In terms of bereavement and family violence, these remain largely the same. In fact, they remain days based, but the difference is they are available from day one, and an employee can take them in part days. In terms of public holidays and alternative leave, what we have is a new otherwise working day test to work out whether the public holiday in question would otherwise be a working day for the employee. Obviously, if the employment agreement is clear and specifies days and patterns of work, then there'll be no question around whether Good Friday, for example, is otherwise a working day. But if that's not so clear, where the difficulty arises currently, then we now have a new test to look at whether that would otherwise be a working day. And it's really quite simple. And I think this is going to be a change that helps a lot of us out. The question will be whether the employee has worked 50% or more of the same day of the week as that public holiday in the preceding 13 weeks. So that should be clear and straightforward. You've then got your capacity to earn time and a half, and alternative leave for any public holiday worked on an otherwise working day. And the time and a half stays essentially the same, but there is some new law around that to get our heads around. It's written differently. And then alternative holidays, as they are called under the Holidays Act, now become alternative leave, which is accrued, and that's accrued at the rate of 1 hour for every hour worked on the public holiday that is an otherwise working day. That alternative leave can be taken on any day of standard hours under the employment agreement following that public holiday, and also can be cashed up at any time. So those are the entitlements, some simplification there, but also some familiarity you'll be pleased to hear. In terms of payment, what we are going to be seeing if this bill becomes law is that we're going to have a single hourly rate on which to pay out all types of leave taken. So there is I won't go through it all now, but there is obviously the bill sets out how that is to be calculated. Following parental and volunteer leave, employers will use the same rate, so that will stop those people being disadvantaged as they have been in the past. And then, of course, as I mentioned, there's this new concept of an LCP of 12.5%, and that's to be paid on any additional hours and casual hours, so that the employee is given something for their leave or holidays there, but of course doesn't accrue annual leave on those additional and casual hours. So the question is, of course, what next? Well, as I say, select committee submissions are due middle of next month. That's fairly quick. So if you obviously want to have a say, then make sure you're getting onto that pretty quickly. If the law comes into force, we expect it to do so, and before the election, there'll be a 2-year period for most employers to roll this out. I know many employers have been telling me that that's really not enough for them. That has sort of been the figure that has been talked about for a long time. So I don't anticipate a shift on that. But obviously, if that's of concern, that's absolutely something to submit on. The schooling sector, though, does get 10 years to work this out, but the rest of us need to deal with 2. So look, I think practically the major to do, the major takeaway right now is to really look at whether you're wanting to submit. There's been extensive consultation with payroll teams and with business, but obviously not every scenario can be worked through. So have a look. The explanatory note at the start of the bill is really, really helpful in terms of getting a great overview. And then, of course, your payroll teams may want to look at the nitty-gritty of the calculations to make sure that everything makes sense from their point of view, and obviously raise any points of uncertainty or lack of clarity. And then, of course, we'll see this quite possibly coming into the law very, very shortly, the Employment Leave Act. So with that, Peter, I'll pass back to you because I think we have now covered the content that we intended to do, and I'm not sure whether or not there's been some questions, but we can certainly address those.
Thanks very much, Hannah. Thanks very much, David. Just on your comment, Hannah, I think the timeline is very important. Looking at the list of attendees today, I'd encourage you to make submissions. We're quite happy to help you make a submission, but this is a once in a generation change. Phil Doak and I sat in 2013 on the Holidays Act review, and a number of these reforms have come through. I think the hourly rate calculation is going to make things easier and more satisfactory. But one thing we know about employment law is that it's a developing and moving feast. And I think there's 2 developments that have happened we need to keep half an eye on. One is that these reforms have been very much driven by the current Minister of Workplace Relations, Brooke van Delden, who has announced her retirement. She's the current minister. I'm conscious there's some Australian and overseas people. Will that make a difference? Possibly. We have to wait and see. And secondly, of course, we have a general election here in November, and I've got an eye on to what the opposition parties' policies may be and how they might affect it. So we've always got to have half an eye on that. Well, look, we do have some specific questions, and the first one, Hannah, is for you, and this is the question. If standard hours are more than 40 hours per week, will the annual leave that you accrue end up being more than 4 weeks? Good question.
Well, it will because you're accruing on each standard hour at a particular rate. So you'll get the essentially the proportion of leave based on the standard hours worked. So in short, yes.
Thank you. David, serious misconduct. The question is, what is the grey zone? And when that question came through, I chuckled because I thought, how long is a piece of a string? And you in your presentation said it's very subjective, but my subjectivity is different to your subjectivity. What are the grey areas?
Yeah, so it's very factual. The courts have declined to give a definition of serious misconduct over the years. The Court of Appeal has declined to do so in some very famous cases, famous to lawyers who practice in this area, not famous to anyone else. So the grey area is always going to be around. You'll have your obvious areas, which is you can prove dishonesty. If you've got an honest belief based on reasonable grounds, you can prove violence in the workplace if you've got an honest belief based on reasonable grounds. But when you get into areas such as bringing the employer into disrepute, negligence, recklessness, and the like, which may be categorized in your code of conduct as serious misconduct, the courts may not necessarily take the same view as you. And that's why it's important, particularly when you're investigating serious misconduct, to follow a thorough process, because you want that information. You want the benefit, if you ever have to rely on it, of being able to say, well, we don't think you're entitled to any remedies. And the reason is we followed an extremely thorough process. We were entitled to form the view we did. We had an honest belief based on reasonable grounds that you engaged in the serious behaviour we alleged, and therefore we are confident that even if you're right that some of our processes were flawed, that the behaviour constitutes serious misconduct and you will be entitled to no remedies. And that's what you're looking to do if you're in a mediation or in a negotiation, should they have raised a personal grievance challenging the dismissal.
Hannah, a question: when a team member reduces hours, will they retain the annual leave accrued?
Yes. One term that's been used a little bit in the explanations is that you essentially bank the hours that you accrue. So once you've worked that standard hour and you bank your 0.0769 or whatever leave on it, then that is there for good for you to use, or of course to be paid out. And there are those standard sections around paying that out upon termination of employment, but it's locked in. And of course, then when you go to reduce your hours, you will accrue less leave or fewer hours because you're working fewer standard hours of work. But what you did before is still locked in.
Very much, Hannah. Next question: are there any salaried roles that are exempt from additional hours?
Yes, and I should have said that. The additional hours calculation or definition under the Act does provide a carve out for where somebody is on a salary and where there is no additional requirement for payment for those additional hours worked. So essentially, you've got a salaried worker carve out there for additional hours, yes.
Next question: regarding the gateway test, would you recommend that we have clauses with the independent contract agreements that reflect the section or the 5 requirements?
Look, I think it's an interesting question, because before we think about drafting new agreements, or maybe entering into new agreements with existing people, we have to think about whether we actually want to use this gateway test, whether you want the person to be a specified contractor. And I think that's going to come down for most businesses on to those 2 criteria that I noted regarding, can we restrict their work for others? Are we able to not do that and therefore avail ourselves of the specified contractor test, or do we need to put some restrictions around? And similarly, do we need to put some restrictions around when we need them to carry out their services, or are we happy for them to subcontract? Now, those are the questions that I would be asking. I've been talking to some of our clients about. If the answer to those is yes, we're quite happy for them to be able to work for others, and look, they can carry out the services absolutely whenever, or more than happy for them to subcontract, then you'll be looking at wanting to use the specified contractor, gateway, I suspect. And in that case, then I think that for most people, you want to be quite clear in your drafting that you're meeting each of those 5 criteria. Yeah.
Next question: what consultation or notification obligations do employers have under good faith principles in relation to employees who are above the high income threshold and impacted by these changes? That's a good question, and that's the one I'm getting in the Coro Club or in the foyer of our building. that people are asking that same question. Well, this law's come in. What do we have to do now?
Is that from me, Peter?
Please.
So what the Act says about the high threshold income is that a certain part of good faith obligations or the duty of good faith that's set out in the Employment Relations Act does not apply to to employees who earn above the threshold, but other parts do. So the obligation to be active and constructive and responsive and communicative, the obligation not to mislead and deceive or do anything likely to mislead and deceive still applies. So that would suggest that there's an obligation to have some sort of engagement with an employee of some nature before you terminate their employment, rather than putting what they say in America, what is it? Putting the worker comes to their desk in the morning and finds the pink slip on the desk in certain states of America. So there's a failure to have some form of engagement aligned with your duty of good faith could create issues for you. Of course, if you can't pursue an unjustified dismissal claim, then you can't pursue an unjustified dismissal claim regardless of those flaws, but you might pursue a breach of duty of good faith claim, which has penalties. You might use that to support some type of discrimination type argument. So it's a bit like the 90-day trial period. It shouldn't come as a complete shock to the individual, ideally, that their employment is going to be terminated or is terminated. There should be something which has some type of engagement which has occurred before then. There may be exceptions where I can imagine in restructuring or urgent restructurings or urgent directives from the CEO where that's not going to happen. But as the norm, there should be some form of engagement, would be my recommendation.
On the gateway test, the next question, how do you see the gateway test interacting with the common law test over time? Do you expect one to dominate in practice?
Oh, look, my view on that is I think we are still going to see a number of cases looked at on the same basis as we have seen in recent years and for many years past, that real nature of the relationship test. I think that obviously where businesses can, they will avail themselves of the specified contractor category. But we're going to see that fail in certain circumstances, and we're going to see a lot of businesses who feel that they can't quite fit themselves into those 5 criteria and therefore rely on their existing arrangements. And to those, the old test is going to apply. So I think we're still going to see a decent amount of Section 6 employer status argument. But there will be businesses who are able to carve themselves out of that. And then there will be the messy situations, obviously, particularly as this new part of the law is in its infancy, where somebody claims the specified contractor defence, I might say, but then that fails and then the court goes on to assess under Section 6. So I think we're still going to see that quite a bit.
Yes, I've noticed in my career a change in the Uber case in the Court of Appeal, um, where I was for Business New Zealand. I really noticed being in competition, can you work for a competitor, was important. But whoever the question is, it's a good one. I often look at the Inland Revenue website too, because they have certain tests that are set out, and the Inland Revenue tests are not necessarily the same as the employment law tests. Next question, Hannah, is for you, and this is a predictive one. Do you think that the final act for the holidays or employment leave will change much between what we have now and after the select committee process?
I don't anticipate. I mean, there's some typos in there, so those will be ironed out. But and there may be some tinkering around the edges, but I have a feeling that I mean, nobody's, you know, you can never get everybody happy, but I have a feeling that we'll see this largely go through in the way that it is. Maybe just some tweaks to the exceptions and the calculation points and the finer details like that. That's my prediction, but I haven't got a crystal ball, so I don't know.
My response to the questioner is if there are areas that you think should be changed, put in a submission. You don't have to appear at the select committee. You can do it in writing. Whoever you use at our firm, you're very welcome to run it by us. I'd encourage you to do so. So just in concluding, I've got four points that I would like to make. Those of you who need a continuing professional development certificate, do let Gina in our office know. A number of you have asked for that. Very happy to do that. Secondly, we as a firm used our LinkedIn page for legal updates. Our feedback in the past have been, don't bombard us with emails. So if you're not joined into our LinkedIn group, you're very welcome to do so. Next point is let us know whether you like in-person seminars or webinars or mixed. We really do like feedback. And that really leads me to my final point. If there are any other topics that you think a webinar or a seminar would be useful, please let us know. Just let your normal client advisor know by feedback on all of those points. David and Hannah, thank you for the presentation. We will be having some notes on the slides available to you and we'll send. If we haven't answered any of your other questions, don't hesitate to let us know, either Hannah, David, or your normal client advisor. Thank you very much for attending.
Thank you.
Thank you.